Hello, everyone. Good to be back. I know our schedule got a little off. I know Gabe was here the past 2 weeks, but we're back to our every other week cadence at this point. Before I get started introducing today's presenters, I wanted to give another reminder that our breakfast briefings in the Labor Department are ongoing related to the pregnant worker. I did the presentation in Binghamton last week. Hello to those of you who are there who I know listen to this webinar. Really great session, a lot of information. I think, some might think, how much is there to know about this topic? A whole hour and a half, really. And there really is plenty of material. The new Pregnant Workers Fairness Act has some really surprising and unexpected requirements that we're all just learning based on recently released regulations. So plan on attending if you haven't signed up yet, and if you've got a location near you. So with that plug, let's move on to today's agenda. So we have another great lineup here covering a very wide variety of topics today. So we're going to start with an employee benefits topic from one of our esteemed employee benefits attorneys who's located here in Syracuse. That's DJ Nugent, who'll talk about some new DOL guidance. We have an associate in our Rochester office, Connor Johnson, somewhat new to the firm. Today is his first time on the webinar, so we're really happy to have him talking about a topic related to school law. Then we have Arthi Chandin talking about a wage and hour topic, a de minimis doctrine related to overtime claims. And then we're gonna close things out in higher ed with Kate Hajar down in New York. So like I said, really wide variety impacting different industries. Hopefully there's something for everyone today. So with that, we're going to go ahead with our first presenter, DJ Nugent. Thanks for being here, DJ.
Of course. Thank you, Kristen. So as Kristen indicated, what I'm going to speak about today is a relatively recent piece of guidance from the United States Department of Labor regarding cybersecurity for employee benefit plans. And Kathy, if you could go to the next slide, please. On September 6th of this year, the United States Department of Labor issued a press release in Compliance Assistance Release number 2024-01. And what those pieces of guidance did is they built upon cybersecurity guidance that was issued by the DOL in 2021. And the 2021 piece of guidance is really what the substantive guidance on this issue is. So just for purposes of clarification, I'll refer to what was just issued as the 2024 guidance and what was issued in 2021 as the 2021 guidance. The 2024 guidance was generally very limited in scope. It confirmed an item, provided some updates, and really just restated what the DOL said in 2021. So the two big picture items that the DOL said with the 2024 guidance is it confirms that the 2021 guidance applied to all employee benefit plans that are governed by ERISA. So generally, most employers are subject to ERISA unless you are a governmental plan or a church plan. So very wide-ranging variety of plans are covered. There was some that thought when the 2021 guidance was issued that the cybersecurity guidance that the DOL issued only applied to retirement plans. And I think that was generally because the guidance references many retirement plan topics, and I think for good reason, because retirement plans are a literal treasure trove. For cyber criminals, there is just a pot of money sitting there for criminals to try and attack, but the DOL wanted to confirm that their cybersecurity guidance does apply to health, dental, vision, all of those types of plans as well. The 2024 guidance also provided some slight updates to what the DOL said in 2021, some time period, some suggestions on obtaining insurance or asking about cybersecurity insurance, but really nothing groundbreaking there. But I thought because the DOL is reissuing this guidance and is focusing on cybersecurity compliance for employee benefit plans, it would be good to just provide an update of what they said in 2021. So if you could go to the next slide, please, Kathy. The 2021 guidance was issued in the form of cybersecurity best practices, and it focused on 3 topics and was really issued in 3 separate documents. I'm going to go through each topic that was issued in the 2021 guidance very briefly and not in an exhaustive fashion by any means. So if you have questions on this, I'm happy to answer, and you can also look at those pieces of guidance in more detail if there's something you think that sticks out in your mind is something that you remember that I don't have on the slide here. The first topic was hiring service providers, and how the DOL broke down the 2021 guidance was really who was their audience that they were targeting with each piece of guidance. The audience for this first topic is employers, so ERISA plan sponsors and the fiduciaries that govern those ERISA plans. So plan administrators, fiduciary committees, those types of individuals. That's who this piece of guidance was directed to. And as the title indicates, this guidance is directed at tips to hire your 401k plan record keeper, your investment advisor, your vendor for your health insurance plan if you're self-funded, or maybe brokers if you're insured. What do you need to look for when you're hiring one of these entities to provide services to your retirement or health and welfare plan? Very quickly, what the DOL says on this topic is that plan fiduciaries must act prudently when selecting and retaining service providers. And their suggestion is that plan sponsors require their vendors to implement and maintain satisfactory security systems to guard against attacks and prevent potential breaches. And the DOL offers a number of suggested best practices in that regard. I think it's just important to remember, like many other topics where plan sponsors may contract items out with respect to their plan. Hey, we think X entity is going to do this. At the end of the day, if there is an issue, the plan sponsor and the plan fiduciary is going to be the entity on the hook if there is any kind of governmental investigation or any lawsuit from participants. So it's important to understand that your vendors are doing what they need to be doing, and that you're looking to make sure they have processes in place to help protect you as the plan sponsor. Next slide, please, Kathy. The second topic was addressed to the actual vendors themselves. So plan record keepers, brokers, those types of entities. And those are the actual cybersecurity program best practices that the DOL thinks these entities should have in place. So examples are, do those entities have a well-documented cybersecurity program? Are they conducting annual risk assessments? Do they have cybersecurity awareness training for their own employees and for your plan participants as well? Again, that is important for the plan record keepers, brokers, and vendors, but it's very important for the plan fiduciaries and plan sponsors themselves when you're looking at who are we going to hire. Is the entity we currently have acting in the way that we need them to act to protect us, that when you're looking and reviewing those topics, that those vendors are making statements about this is what we're doing with respect to cybersecurity. So not only is it helpful for plan vendors, it's also helpful for plan fiduciaries as well. The third topic is online security tips, and that was addressed at the actual plan participants themselves. So employees, retirees, beneficiaries of health plans. And the DOL does note, and I think this is helpful for employers to be able to say to their employees too, should the conversation come up, that you, participant, play a role in the cybersecurity of our plan. You need to have strong and unique passwords in place. We may implement a multi-factor authentication to log in. I know that's certainly the case for when I'm looking at my 401k plan account, that I get a text message that I need to enter a code in before I can see that. Is that something you have in place? And just to make sure you're regularly monitoring your account as the participant to make sure something hasn't happened that you don't think should have happened. So that, in a very brief, non-exhaustive nutshell, is what the DOL said in 2021. That has been slightly updated in 2024, and with the confirmation from the DOL that those pieces of guidance from 2021, they don't just apply to retirement plans. They're saying they apply to employee benefit plans across the board that are subject to ERISA, so health, dental, vision, life insurance, anything that's an ERISA covered plan, these guidance pieces would apply to them. Kathy, next slide, please. So I think based on the 2021 and 2024 guidance, what's the takeaway? Importantly, neither of those pieces of guidance are regulations or statutes. They are not binding, mandatory pieces of guidance. However, and I don't know this personally, but I've heard it anecdotally from others who have experienced this, if your employee benefit plan is selected for audit by the DOL, or if you're under some investigation for some reason, the DOL very likely will ask you, do you have a cybersecurity plan in place with respect to your benefit plan, and is asking targeted questions about this best practice. I think, like many of us understand, when the government issues something in the form of best practices, that's them saying, we think this is what you need to do. So should there be an issue, this is very likely the position that the DOL is going to take as the minimum standard that you as a plan sponsor and plan fiduciary need to be aware of with respect to cybersecurity for your employee benefit plans. So I think the main takeaway is just to be aware and refresh yourself on this 2021 and 2024 pieces of guidance. We're certainly happy to speak with you about that. But if you think you need to have another discussion, talk to your plan record keepers for your retirement plan, talk to your brokers and vendors in your health and welfare plan, just to maybe have a conversation if you haven't in a while to say, hey, we're aware that there's this cybersecurity guidance. Do you have processes in place, and is our plan doing what it needs to do to comply with the DOL's best practices? Last slide, please, Kathy. The second main takeaway is that cybersecurity for employee benefit plans, the DOL is indicating that is a topic of top priority for them. And that's a developing trend from the DOL. Is we've talked about for years fiduciary governance in the retirement and pension plan world, where we suggest having benefits committees to look at who's your record keeper, who's your investment advisor, what investments are you actually offering to your plan participants, because there was litigation and investigations in that area in the retirement plan. The DOL is indicating that while in the retirement plan world, that's certainly still important, there's a shift to fiduciary governance in the health and welfare plan world as well. And we've spoken about that in some recent webinars, that due to some recent litigation that plaintiffs' law firms are bringing and targeted investigations by the DOL, it's important to have that committee structure for your health and welfare plans as well. Have good fiduciary processes in place. Do we meet as a benefits committee on a regular basis and review the vendors and brokers and benefits offerings for medical and dental, et cetera, that we have in place right now? Are we offering the appropriate benefits to our employees? Is the cost that we're charging both for the benefits and for our brokers and vendors, does that meet indexing and benchmarking when we compare that to similarly situated plans? So it's important to have those processes in place. This cybersecurity guidance should be part of that discussion. It's not only do we have the correct brokers, vendors, and plan offerings, do those entities offer the correct cybersecurity guidance? And I just pulled some quotes from the 2024 guidance, and these are directly from the DOL. And I really want to focus on the last two quotes just to give you a sense of what the DOL feels about fiduciary governance in the health and welfare plan world, as well as cybersecurity. And the second quote says, without sufficient protections, digital participant and asset information may be vulnerable to the internal and external risks of computer-related crimes and losses. Federal regulations require plan fiduciaries to take appropriate precautions to mitigate these risks. So that's the DOL saying you are required as a plan fiduciary to protect your plan and your participants from these types of risks. And the last quote is that the Employee Benefit Security Administration believes cybersecurity is a great concern for all employee benefit plans, and they're going to continue to investigate these potential ERISA violations. So it's a topic of concern for them and potentially targeted enforcement areas moving forward. So it's just important to be aware that this guidance exists, and to speak with your consultants, your brokers, to make sure you have a plan in place to make sure you're in the best position moving forward. So with that, I'll hand it back to Krista.
Thanks, DJ. The thought that crossed my mind is, even if I'm not the one monitoring this at my workplace, as a consumer of employee benefits, this sort of makes me happy, right?
Right.
That my information is being protected. Great. So thank you so much for that update. Always good to have you here, DJ. So we're going to move on to our next presenter, Kathy. Connor. So Connor's an associate in our Rochester office, who's going to talk about sort of something kind of interesting, the idea of having students on school boards of education. So Connor, tell us about this new topic.
Yeah, thank you, Kristen. I appreciate it. Yeah, so like Kristen mentioned, this topic is education-related topic. It's an amendment to New York education law, and although it speaks directly to any school district personnel that may be on this webinar, it's also pretty interesting for any active individuals who might be active in their education communities or their high school districts, or anyone that has high school age students that have expressed interest in policy, political science, or education, and just kind of want to be a part of the sitting in on boards or hearing how policies are made or procedures are having an impact in their school. So excited to share this topic with you. And if Kathy, you can go to the next slide, please. So before we get into the nuts and bolts of things that may have changed in the education law, I just want to kind of give an overview of why we're presenting on this topic today. Earlier this month, Governor Hochul signed into law Bill 9018-A, and it, as I mentioned a couple times, it has amended prior education law. And before we get into what has changed, the purpose I think is pretty important to highlight. And the purpose of this change was to facilitate opportunities for students who are seeking to build habits of civic engagement by allowing more opportunities for students to sit in on boards of educations and meetings, as well as to provide them a voice in these types of meetings. And it's equally important not only for the student to sit there and see how things are made policy-wise, procedure-wise in school districts, but it's also important for the adults in the room to hear from the perspective of a student and to gather that perspective, because they're the ones that are sitting in the classroom, and that, you know, the policy might make sense in an adult's head, but it might not make sense in application. So hopefully it's a change in the education law that results in like a grander scope of not only just an opportunity for the students, but a good opportunity for the school districts as well. So Kathy, if you can go to the next slide, we'll go into some of the specific changes that have happened due to this new bill being signed. So previously, under the old law, one of the key takeaways is districts were allowed to appoint these ex officio student members. So the key word I said is allowed. Now, under the new law, the school districts, and it's school districts outside of New York City that have a high school, as well as all BOCES programs, they have to have a procedure in place, a policy in place by July 1 of 2025 that results in the designation of at least one student ex officio board member. As I mentioned, it's at least one member. It could be multiple members, but before, the key difference is that they were allowed to. So some districts chose not to, some districts didn't result in this. But now, as we mentioned before, the purpose of expanding and providing more opportunities for students to participate in these opportunities is the new law is requiring that school districts have this policy in place that designates at least one ex officio student board member. And Kathy, next slide, please. So in addition to mandating that at least one student is elected, the way in which these students are elected has changed under the new law. So previously, under prior law, school districts appointed ex officio student members via referendum of the voters of the district. That is no longer authorized under the new law. In fact, they are required to establish the process, have a process in place, and the statute provides for examples of what that might look like. So as you see on the slide right there, an eligible student, which now is understood under the new law as all students who have attended the high school for at least 1 year prior to their appointment to the board. So you had to be in school for at least 1 year, and then you are eligible to at least be appointed. So now, how does one get appointed? As I mentioned before, there's no longer referendum via the voters of the district. Now there's types of ways of establishing the process and the procedure. So for example, this individual, the students, or these students could be the student president that could be of the high school, that the board's allowed to, or the school district is allowed to establish a process or a procedure that results in the student president being allowed to the board, or they could be duly elected by the student body itself. There could also be a student elected by the student government, or as you see, elected specifically by the principal, superintendent, or the school board. So again, like I mentioned before, a key change was school districts were allowed to. Now they are required to have a student officio board member. And then now the way in which they elect them, no longer is it the board via referendum of the voters of the district. It has to be a process or a procedure, as kind of illustrated before, with the student being eligible, having just had to be in high school 1 year prior to being eligible for any type of appointment. So Kathy, if you don't mind going to the next slide, please. So what exactly types of experience and what does it mean for a student to sit on the board? So now students are allowed to sit in on board meetings that are any executive meeting or public board meeting or hearing that is available to the public. The students allowed to sit and participate however they feel comfortable, to whatever extent they feel comfortable offering their opinion, and equally as important is providing their voice and their perspective, which is important for school districts to understand as they establish policies and procedures as they apply to students. But they can also listen to different perspectives of board members and different perspectives of where different administrators, are coming from, and trying to understand, what's best for the school district as a whole. So that's a key thing that students are allowed to sit in on and gather that experience. And in addition, boards are allowed to permit student members to participate in other activities and have other responsibilities. And it's of course up to the board's discretion. So whatever the board feels appropriate for the students or students that they've elected to the board, they can provide further opportunity. And again, it's all in alignment with the purpose of the new amendment to this law, which allows for greater opportunities for students who are interested in policy and understanding how the school districts function and the procedures of school districts, to gain that greater experience. So if you can change the next slide, please, Kathy. So of course, not everything's limitless, and we have to make sure that there are parameters set in place for students. So students under this law are not allowed to attend executive sessions or non-public meetings or hearings. And of course, they cannot receive any sort of compensation for their participation on the board. And of course, they're not going to be entitled to vote on any matters that require any sort of vote. So otherwise, students have a great opportunity to sit in, provide their voice, and gather a perspective that's much needed. So as we mentioned before, these policies and procedures should be in place by July 1 of 2025. So school districts are encouraged to start that conversation, see what it is that makes the most sense for their district in terms of the election process. Thank you. I'll just kick it over to Kristen now.
Yeah. Thanks, Connor. Appreciate that. And I think you were right when you said at the beginning, this is interesting, not just to school districts on the line, knowing the need to do this, but parents, right? Who, can pass that potential opportunity over to their students and let them know that might be a possibility for them. So it's exciting. Great. So the next topic, really kind of jumping around here, the Ninth Circuit, we're going to hear about, which is a court out in the West Coast, but talking about a recent overtime ruling. So with that, we have Arthi Chandon from Buffalo, and who will share that with us. Thank you.
Thank you so much, Kristen. So as Kristen mentioned, today I'm going to be talking about a Ninth Circuit Court of Appeals case that rules that the de minimis doctrine applies to overtime claims. Kathy, could we move to the second slide? Yep. So a general overview. We're just going to be talking about kind of what the de minimis doctrine is, and then go through the decision, kind of the court's holding, and what the reasoning behind their holding was. Next slide, please. So the de minimis doctrine, it's a legal doctrine by which a court refuses to consider trifling, or in other words, minimal matters. And in Latin, de minimis actually means pertaining to minimal things. So in the context of a labor and employment law claim, specifically a wage and hour claim, which is what the court case is about, the de minimis doctrine permits employers to disregard, for the purposes of the FLSA or the Fair Labor Standards Act, otherwise compensable work when the matter in issue concerns only a few seconds or minutes of work beyond the scheduled hours. So basically, the de minimis doctrine kind of shields employers from liability for paying their employees for kind of, minimal job tasks. An example of this could be time spent turning lights on or off, or locking up at the end of a shift. In kind of the manufacturing context or construction context, an example could be time spent checking in and out tools before working and then at the end of a shift. So that's kind of an example of what these kind of minimal tasks would be. Could you go to the next slide, please, Kathy? So the Ninth Circuit case that we're going to be discussing today is Connex. So the Ninth Circuit issued an opinion in Carrion Cadena v. Customer Connex. We're just going to call it Connex. And this was at the end of July. And they reversed a prior granting of summary judgment for the employer Connex. And essentially, through this court case, they held that the de minimis doctrine does apply for workers' claims of overtime wages, and that there were triable issues of fact with this particular case as to whether the time that the employees were claiming that they were owed was de minimis or not. So they actually sent it back down to the lower courts to be reevaluated, possibly by a jury. Next slide, please. So just a little bit of background on Connex. Connex is an employer who operates call centers in Nevada. And these particular employees alleged that they violated the FLSA by failing to pay these employees overtime wages for the time spent booting up and shutting down their computers each day. And I'm sure all of us can think about, you know, when we're logging on or logging off of the computer, sometimes it takes 2 seconds, sometimes it takes 5 minutes. It's something that can vary day to day, particularly if there are any, you know, network issues. So this case had been going on for a while. On a prior appeal, the Ninth Circuit actually reversed the district court's earlier grant of summary judgment for the employer. So, and then with that prior appeal, they held that the time that the employees spent booting up their computers is compensable under the FLSA because it's an integral and indispensable part of their duties. So they're saying, you know, they couldn't do their job without booting up and shutting down their computers, so it's integral and indispensable, therefore they should be paid for it. So the case was remanded back, and the district court didn't agree, and they granted summary judgment for Connex. And, you know, they said, you know, we do agree that this time is compensable, but regardless, they're not liable for this under the de minimis rule, which, as I mentioned, allows infrequent and insignificant periods of time outside of the scheduled working hours that can't be measured as a practical matter. So they're saying, you know, because this time couldn't be precisely measured, it can be disregarded even though it's technically compensable. Next slide, please. So the plaintiffs actually appealed this a second time, and this time they argued that the de minimis rule was no longer good law after the Supreme Court's decision in Sandifer, and that's Sandifer versus U.S. Steel Corp. It's a Supreme Court decision from 2014. And in 2014, in Sandifer, the Supreme Court held that the de minimis doctrine did not apply to a provision of the FLSA concerning the time spent changing clothes or washing. So ultimately, you know, the Ninth Circuit disagreed with this reasoning and found that despite the ruling in Sandifer, it didn't disturb the applicable case law with respect to the circumstances at issue. So with respect to the time, you know, booting up and logging off. And they held that the de minimis doctrine still remained applicable for overtime wages. Next slide, please. So basically, the Ninth Circuit's reasoning, they had to evaluate whether the time at issue, the time the employees spent booting up their computers, was de minimis by applying a 3-factor test that was set up by a previous Ninth Circuit decision in Lindo, which is a case from 1984. So the 3-factor test analyzes 1, the regularity of the work at issue, 2, the aggregate amount of time spent on the work at issue, and 3, the practical administrative difficulty of recording the time. So in analyzing the first factor, you know, the regularity of the work, the court found that while the time spent on the activity varied each day, so the time spent booting up and logging off varied each day, the work regularly occurred because the employees were required to boot up or shut down their computers each shift. With respect to the second factor, the aggregate amount of time at issue, the court found that there was, a question of fact as to the amount of time that employees were spending booting up and shutting down the computers, because as I mentioned, this time varied, right? And it depends on the processing speed of the computers, things like that. So it can take anywhere from a few seconds to, on a bad day, 30 minutes if the network isn't working. And finally, in analyzing the third factor, the practical administrative difficulty of recording the time, the court explained that the employer Connex could estimate the time spent booting up or shutting down computers based on the time the employee swiped their badge immediately preceding the clock in time and the badge swipe immediately following the clock out. So they said, it could, logically be done. Next slide, please. So kind of what does this mean going forward? Now, the Ninth Circuit here in New York, we're in the Second Circuit, but this case law is still instructive, right? And the Ninth Circuit holding that the de minimis doctrine can apply to overtime claims, kind of, it suggests that employers have to bear in mind that several of the factors considered by these courts could apply in a bunch of different contexts, including in call center environments, as I mentioned, maybe in construction environments. It can apply in a wide array of circumstances. And also underscores the importance of employers accurately recording and compensating all time that their employees spend on job functions, including preparatory activities such as booting up a computer. Now, with specific regard to Connex, now the district court, perhaps through a jury, they have to reconsider the difficulty of the employer in tracking down, the booting up time and the shutting down time, and how much time that really takes. And that can be difficult because, as I said, it can vary. So I think kind of the takeaway from this is even though this defense may still be available, it's a hard one to kind of prove, and employers should really be accurately measuring the time that their employees spend on all tasks.
That's great. Thank you so much. So that was your last slide, right? Okay, you didn't actually say that. I just thought, just based on the conclusion there. Yeah, but interesting because I think you're right. The takeaway is, this employer won and we're able to use the defense, but we don't ever want to like put your eggs in that basket. Like it's definitely better to track the time. It's and it can be easy to forget that sort of thing, right? That happens, just before or after work. So thank you so much for that really helpful reminder. Let's move on to our final presenter, Kate Hajar, who's senior counsel in our New York City office, talking about another student topic, this time in the higher ed arena, a new law that was just passed, the New York State Student Lifeline Act. Thanks for coming on and telling us about it, Kate. And I know you just wrote an article about this as well that you can get on our website. So tell us about it.
Thank you, Kristen. Good afternoon, everyone. I have an important alert for those on the call who are members of higher education institutions in New York. Earlier this month, Governor Hochul signed the Student Lifeline Act, which becomes effective July 1st of 2025. And this certainly appears to be timed for the start of the 2025-2026 academic year. This act amends the New York State education law and requires two things. Thank you, Kathy, for flipping the slide. So it requires two things. First, that colleges and universities in this state, in New York, share with faculty, students, and staff resources that describe when to dial or text 988. 988 is the emergency number, the lifeline that is the subject of this new law. And so, colleges are now going to have an obligation to share with their community members, specifically faculty, students, and staff, educate them about when to dial that number if they or someone they know are in crisis. So second, in addition to this education component, the second requirement is that colleges and universities in New York, specifically now, print on student ID cards information about 988 and mental health and substance abuse services. If a university does not issue student ID cards, they must issue this information annually in another format. These requirements also, or specifically the requirements pertaining to student ID cards, apply to those student ID cards that are issued, modified, altered, or amended, this is language from the statute, on or after July 1, 2025. So the purpose of this legislation, as you would imagine, is to prevent suicide. It is to prevent and alleviate the effects of substance abuse. It is also to promote mental health among students, among faculty, staff, and certainly those who they may be concerned about in the state. The further purpose of this new law is also to make available, widely available, I should say, and accessible 24/7 important crisis and mental health services that those can access via the 988 number. The services accessible through this lifeline are confidential and significantly free. So this is an important set of requirements for higher ed institutions about significant, impactful services available in New York. And if any institution has questions about how to implement this, headed into not this, obviously this academic year, but next academic year, please do reach out.
Okay, great. So just a quick update, but appreciate that, Kate.
Yeah.
All right. So that wraps us up today. Thanks for everyone for coming. On our next slide, we have contact information for all of our attendees. There was a couple questions here that we didn't get to today. I was actually just typing a response to one of them. I just realized it, and I didn't get to finish it. So we will reach out separately afterwards. And but thank you for coming, and see you next week.